representative. So I'm going to a very quick introduction of Dr. Miles McLean. Okay, get the right pronunciation. And he is a retired law professor. He is chair of the Policy Review Committee for CCJA as well, which we really appreciate. But he's also the editor-in-chief of the Wrongful Conviction Law Review. So he's done a lot of work in this area of Miscarriage of Justice Review Commission. So I'm going to turn it over to him. We have an hour session, and we'll have time at the end for questions.
Thank you, John. Hi, everybody. Thank you very much for coming today. I appreciate it. I'm very pleased and honored to be here. This is a treat, especially coming to a place like Banff, obviously. As you can see from the slide, in addition to the CCJA role I have, I am editor-in-chief of the Wrongful Conviction Law Review. It's been around for about 5 years. It is now the world's leading journal on wrongful convictions and miscarriages of justice. We have an editorial board with Canadians, Americans, New Zealand, Australia, England, Scotland, Poland, Israel. So it's truly international scope, and we're very proud of the journal. So, it's a very good instrument for anybody who is studying in the field. And my field is wrongful convictions. I did my doctoral research my education in that field, and as a function of that, today. Wrongful convictions is something that is a very important topic, and I'll have a quick slide about that in a few minutes. But it's incredibly important, and the reason it is that people now understand that actual physically and factually innocent people are convicted, and that wasn't the case 35 years ago. So up until the mid-1980s, most people knew that wrongful convictions took place. And when I say most people, I'm talking about people in the justice system, so judges and lawyers and prosecutions, what have you. They knew that they took place, but it was pretty much the cost of doing business. No system is perfect, and everybody accepted that. And they also pretty much figured out that there likely was wrongful convictions, but so what? It really just happens, and let's move on. It wasn't until the advent of DNA analysis, or at least the sophistication of DNA analysis, where it was actually irrefutably proven that people were imprisoned, some put to death, and were in fact innocent. So it was that moment when actual people representatives of the system understood that, you know what, this is a real problem. And we'll talk about the numbers and what kind of problem that is in a few minutes. But anyway, that's my field, and more than that, my specific focus in wrongful convictions is on compensation. So that's really my real thing. So while it's incredibly important to exonerate those who are wrongly convicted and in particularly wrongly incarcerated, my research and writing has focused on compensation. So what do we give those people who are in fact exonerated? What do we do for them to build their life, to rebuild their life? Because I guarantee you, any period of time of incarceration, anything from 6 months and up, you're going to lose your home, you're going to lose your vehicles, you're going to lose your job, and when you get released, the state, for the most part, doesn't do anything for you. There's a lot of jurisdictions that have some systems in place. In the United States, there's about 40 states, including the Washington, D.C. and the federal government, that have what are called compensation statutes, which pay people X amount per year for the number of years incarcerated. And so, and that's a statutory scheme that's in place, but they vary tremendously. Wisconsin only offers about $5,000 total, no matter how many years you've been incarcerated. Texas is actually quite generous. Texas pays anywhere up to $100,000 per year if you were on death row. But it's also the highest capital state in the U.S., so if they don't kill you, they will pay you. So in any event, we don't have in Canada any system like that. Right? We just do not have it. We have a very old, antiquated system put in place in 1988 that has paid some very large awards. Stephen Truscott, $6.5 million. David Milgaard, $10 million. Williams Mullins Johnson, $4.25 million. Those are the big awards that get lots of press, but they're very few and far between, and absolutely nothing for the vast majority of those who don't make it into those headlines. Anyway, that's my background. So anyway, today we're going to be talking about the prospects for Indigenous, Black, and marginalized accused persons, and what their prospects are going to be, as in the numbers really of how they're going to do when or if a Miscarriage of Justice Review Commission is put into place. All right, so this we're going to talk about. So section 691, 696.1 of the criminal code, that's the current system. I'll talk about the new system. I'll talk about what are the factors of wrongful convictions. They're very well known, and how they are impacted by those in these groups of Indigenous and Black and marginalized accused. We'll talk about the number of convictions that take place in Canada, the number of those that are in fact wrongful, right? And at the end of the day, I'll break it down into how many potential applicants in total, and marginalized applicants do I think will be coming to this commission once it's put in place, and again, if it's put in place. All right, it's important to realize that the new process that's being put in place is not restricted to just homicides. Right? So for those of you who are familiar with Innocence Canada, I'm a member. Innocence Canada is Canada's leading innocence program that exonerates individuals, but they only deal with homicides. The new system is not restricted just to homicides. And what that means essentially is that there's going to have to be another new miscarriage of justice program. It could be called anything, a project or a program or what have you. But there's going to have to be another program put in place that's going to assist all of those that still aren't funneled through to Innocence Canada. So the idea was to be able to determine how many potential applicants there may well be to this new commission, is to look at all the other internationally recognized commissions worldwide. I'm going to do that. So we'll look at those numbers, and then I'll try to translate those into a Canadian number for you. All right? And apart from the abolition of capital punishment, again, the issue of wrongful convictions is the #1 criminal justice reform issue pretty much in the world. Everybody recognizes how important it is, particularly in places that still have capital punishment. All right, so firstly, section 691 of the criminal code. So the current process is an application under the criminal code to the Minister of Justice. Right? And this is a bit of a problem. And it's a problem because the applications go to the same department that basically is in charge of criminal justice in Canada. So it's looked at as basically an internal kind of thing. So what we have under 696.1 of the criminal code is a process where you have a wrongful conviction group. It's 3 or 4 lawyers that work in the Department of Justice. They receive applications, and then they make recommendations, and it goes to the Minister of Justice, and the Minister of Justice decides whether a matter will be referred for further examination. On February the 16th of 2023, so last year, the current government introduced Bill C-40 to create the new Miscarriage of Justice Review Commission in Canada. And that was after a commission had been put into place, run by former Ontario Court of Appeal Justice Harry Laforme and former Quebec Superior Court Justice Juanita Westmoreland Traore. Right? They put together a group to basically talk to everybody they could, basically, on this issue as to how to create a new commission. So not only did they talk to actually wrongfully convicted persons, refer to them primarily through Innocence Canada, but they talked to interest groups around the country. They talked to other innocence commissions around the world, England, Scotland, Norway, New Zealand primarily. There's a conviction integrity unit in North Carolina. They talked to them. So they put a lot of work into basically making a proposal to the Department of Justice. This is what we think a Miscarriage of Justice Commission should look like, right? The title of the bill was also called the David and Joyce Milgaard Law, right? And that was actually the idea of David Lametti, who was the former Justice Minister. This was his baby. Unfortunately, he's not Minister of Justice any longer, but it was his thing. And so he named it after basically David and Joyce Milgaard. All you would probably know who David Milgaard is. David is now passed away relatively recently. Spent 23 years incarcerated for a murder he didn't commit, right? And it was a terrible set of facts. The person who actually did commit the murder was known to the police. The person's wife told the police that, hey, you know what, I think it was actually my husband that killed this young woman that allegedly Milgaard did. They ignored all of that, right? And after, again, 23 years of incarceration, his mother, Joyce Milgard, was unrelentless in getting attention brought to her son's plight. And she did that by actually talking directly to Brian Mulrooney. At the time, she met with him. He was on a tour. She came up. He had her called over to his limousine, talked to her, and then put his Minister of Justice, Kim Campbell at the time, on the case, saying, look into this. I think this woman has something to tell us. And he was absolutely right, so good for him. And good for these. They're both now deceased, unfortunately, but it's an honor for them to have this legislation named after them, all right? The bill is currently in the Senate. The second reading is in the hands of the Senate Committee on Legal and Constitutional Affairs, and this is where things get tricky. Up until probably last week, I wasn't sure I was coming to the conference this week, because if the government falls, so does this. Right? And this has been taking a long time. It took a long time to get through the Commons. It got to the Senate last spring. They pushed it through to the second reading before the summer break, and it's not on the agenda moving forward right now. So I check the Senate meeting schedules regularly now, and Bill C-40 isn't on it. And it still has to come up for committee. It still has to come up for witnesses being called to the committee. Hopefully they can do that relatively quickly. And of course has to get third reading and royal assent, all before somebody pulls the plug on the current government. Because if that doesn't happen, this doesn't become a reality. And that's gonna upset a lot of people. I can tell you just anecdotally that in the last week, up until the last week, I hadn't seen anything from the current Minister of Justice, his name is Rani, on this issue. But for some reason, I don't know what it is, last Wednesday, my wife and I attended a gala put on by Innocence Canada, and he had a clip that came up that basically talked about his support for this bill. This past Friday on his Instagram account, he had another clip that he posted, although a much longer and more explanatory one, on why this bill is so important. And then this morning, you all would have seen him on the video this morning's opening session, and he mentioned the bill again. Right? So this is a minister really hasn't shown much interest in this bill at all, and now in the last week, is basically prolific on his support for it. What that means, I don't know. It's good news, at least theoretically, but we'll see. But at the end of the day, this has to, in real terms, this has to get passed this fall in order for it to become law, because you want to second guess what the Conservative government's going to do if they're elected in the next election, but this kind of thing is not a high priority. There never has been for a Conservative government. Okay. All right, so and I'm going to work on the premise that this bill becomes law. So once it becomes legislation, it does two things. A, it establishes an independent body, and that's why I mentioned that the current system is somewhat internal to the Department of Justice. We're going to have an independent body, up to 9 commissioners appointed across the country, most of them part-time, certainly the chair is going to be full-time, and only half are allowed to be lawyers, and that's the legislation. So they want other people other than lawyers to be commissioners, right? And that's for a number of reasons. The Reform Commission, when they put the proposal forward, specifically said we want 3 Indigenous members on the committee. We want 1 Black member on the committee, that kind of thing. But the legislation didn't do that. It just simply said we won't have more than 50% of the members as lawyers. All right. So it's going to be independent, and it will replace the existing process. And the most important thing that it's going to replace with respect to an application point of view is that the current process under 696(1) basically says that a miscarriage of justice is likely to have happened, which means to a great degree that it probably has to have happened. And that's a burden. The new commission is talking about miscarriage of justice may have happened, right? So it's a lower burden. So the Conservatives, that's why this bill was in the Commons Committee second reading for as long as it was, because the Conservatives wanted the bill to be changed from may back to likely, and that didn't happen because they didn't have a majority. Okay. One of the driving forces behind the introduction of the bill is clearly the overrepresentation of Indigenous and Black Canadians in the prison population in Canada. Most of you would be aware of this, I would presume. The percentages are, they fluctuate, but they're fairly common, they're constant, basically. While Indigenous Canadians make up approximately 5% of the Canadian population, 30% of the prison population are Indigenous. And that is an amalgam between the federal systems and the provincial systems. So in federal penitentiaries, about 20% of the population are Indigenous, but in provincial jails, right, for those who are sentenced to 2 years less a day, particularly in the West, it's up to 50% of the population. So that 30% figure is an amalgam of the provinces and the feds, all right? And overrepresentation is even much higher for Indigenous women and youth, right? So it's clear that a remedy has to be put in place. Of the 20 cases, and that's always been under 696.1 since the system's been in place, of 20 cases before the Minister of Justice over the course of the last 20 years, all of them were men and 18 of them were white. So that clearly doesn't reflect the overrepresentation of Indigenous Canadians in the prison system. The process has been in place since 1892. That's when the first Criminal Code of Canada was put into place. And again, the process involves exceptional requests for an extraordinary and highly discretionary remedy that derives from the royal prerogative of mercy, which is still in the code. The minister may make a referral to the Provincial Court of Appeal where the crime took place, or can order a new trial. So it's almost always a referral to the Court of Appeal. And that the miscarriage of justice likely occurred, which requires it to be probably, as in without very much doubt. So therefore it places a very heavy burden on the applicants. And it's very hard to basically rebuild. First off, most of these people are, if they're imprisoned, have very limited resources. And so to rebuild a case to go before the minister and prove more likely than not that you're innocent, as an almost factually a certainty that you're innocent, is incredibly difficult, right? The minister won't exercise his or her discretion for a new trial unless there's new and significant evidence. That's also a test for most appeals as well. And most applications are denied after the preliminary assessment, right? So let's talk about wrongful conviction factors. The factors that lead to wrongful convictions are very, very well known. Canada actually is a leading jurisdiction in the world with respect to these factors being published, because we've had 7 royal commissions, or public commissions basically, into wrongful convictions. And 6 of those were based on one person who was wrongly convicted, and a commission was established to consider 2 things. Firstly, A, how did that happen to that person? And B, what can we do to fix it? The 7th commission was called the Gouge Inquiry, and it didn't deal with a single person. It dealt with, in reality, about 32 people who were the victims of Dr. Charles Smith and his faulty forensic pediatric evidence. All right, so these are the names of the people of the commission. Donald Marshall Jr., the very first one that took place, Guy Paul Moran, Thomas Sofino, Ron Dalton, James Driscoll, David Milgaard, and again, the Gouge Report. Okay, these are the factors. And not only are they well known as a function of the public inquiries that we've had, but it's universally accepted in the United States and in Europe and Australia and what have you, the UK, that these pretty much are all the factors that lead people to be wrongly convicted. And we're going to go through them shortly. Right, so tunnel vision, mistaken eyewitness ID, false confessions, jailhouse informants, ineffective defense counsel, prosecutorial misconduct, and faulty forensic evidence. And when I go through these with you, I'm going to be stating things that relate to people in the criminal justice system, mostly police, sometimes Crown, who do things that cause wrongful convictions. I don't do that as a criticism of them, although obviously they get it wrong, but this is what the commissions have all found. Right? So it's not a personal opinion, it's what these commissions have all basically determined to be the causes. Right? So tunnel vision. So tunnel vision, and you may well know this, is a single-minded and narrow focus by the police on a particular investigative or prosecutorial theory so as to unreasonably color the evaluation of information received and one's conduct in response to that information. They look at somebody, they decide that's who we think is guilty, and the case is carved and designed to make that person guilty. When evidence is incorrectly filtered, a biased approach takes place. So what happens is that, and again, This is the function of a lot of experience. What happens is the police look at somebody, they decide that they're the most likely person to be the culprit of the crime, and they look virtually only at inculpatory evidence and ignore exculpatory evidence with respect to that person's guilt. And it's quite often it's reinforced by the police and prosecutions assigning the case without critically assessing evidence or testing the theory. And there's lots of reasons why this takes place. High-profile criminal cases, particularly those involving gruesome facts, tend to inflame the passions and create intense pressure on the police to arrest as quickly as possible, right? And that's a very natural reaction to it. So it's not their fault that this happens, it's just what happens. This in turn intensifies pressure on the investigators to identify a viable suspect, speed becomes an overriding factor, and tunnel vision sets in. In that regard, police often use race as indicators for patrols, arrests, and detentions. For example, police in cities tend to patrol bars and streets, for instance, where Indigenous or Black people of color congregate, rather than private clubs where the white population meet. And that takes us to Donald Marshall. Right? Donald Marshall was wrongly convicted of murder in 1971 and released in 1983 on the basis of new evidence. That's him, right? This was the first public inquiry into wrongful convictions in Canada. This case was also a very clear example of how an Indigenous accused was racialized in the criminal justice system by the police, the Crown, and the courts. I'm not going to give you all the background facts as to what happened leading to his arrest, but if you read them, it's pretty clear that basically the police manipulated two young people who said they were witnesses into fingering Marshall when they knew he in fact was not the murderer. And this is a quote from one of the jurors, and in Canada it's against the law to basically have a juror reveal anything that takes place in the jury room. But this one juror did. And this is what she said, after the conviction of Marshall. With one red skin and one Negro involved, it was like two dogs in a field. You knew one of them was going to kill another. I would expect more from a white person. We are more civilized. That's, anyway. The ways where the criminal justice system systematically discriminates against Indigenous people are the Indigenous accused are more likely to be denied bail, we'll talk about that in a second, spend more time in remand custody, and are more likely to be charged with multiple offenses. The impact of over-policing has led to a great distrust of the police by Indigenous, Black, and marginalized individuals. Over-policing also leads the police to forming attitudes that these groups are violent, dangerous, and prone to criminal behavior. According to provincial court statistics, 22% of Indigenous persons appearing in provincial court faced 4 or more charges, compared to only 13% of non-Indigenous accused, i.e. white. At the other end of the scale, while 50% of non-Indigenous accused faced only 1 charge, that was true for only 37% of Indigenous accused. Okay, mistaken eyewitness identification, right? It's really, apart from tunnel vision, which almost takes place in almost all cases to a great degree, the most individual factor that leads to wrongful convictions is in fact mistaken eyewitness ID. Eyewitness ID is an incredibly poor way to basically convict somebody. It happens in almost 80% of all wrongful conviction cases, where the witness picks out the accused and does it incorrectly. And the danger to that is that if a jury is hearing the evidence from a witness who stands in the witness box and points to the accused and says, yes, he or she is the one that I saw commit the crime, the jury is going to believe that. 100% they're going to believe that, right? It doesn't matter, how sure the witness is or not, right? They're going to believe that person is credible, that witness has no reason not to tell the truth. There's nothing to gain by not telling the truth, and so they'll believe them, and that's pretty much the end of the route to being not convicted, right? There are a number of factors that affect memory, such as obvious, such as the lighting and the time of day of the event when the witness observes the incident. Most witnesses think that the event takes place over a longer period of time. It actually does, and that builds their confidence in their ID. There's also a weapons focus. Weapons focus, this is all psychology and it makes a lot of sense. If you're in a place where somebody has a gun or a knife, right, and they're about to commit a crime, and you're there, that's what you're going to be watching. Right? You're not gonna be looking at the face of the person who's holding it. You're gonna be watching that to make sure it's not coming towards you, right? So the witnesses often can describe the gun and knife accurately and not describe the person who's holding it. And it's also been shown that there's a very strong correlation between confidence level and the accuracy of witness testimony. What that essentially means is the more confident a witness is as to the identity of the person they're basically fingering at trial, the more likely it is they're wrong. The more confident they are, the more chance they're wrong. And of course, the more confident they are, the more likely the jury is going to believe them. For Indigenous and Black accused, studies have shown that cross-racial ID is particularly difficult, especially if it's a white person making that ID, right? A Caucasian witness more likely to have a difficult time identifying an Indigenous or Black suspect correctly. The police can also provide an intentionally prejudicial in-person or photo lineup of suspects. This doesn't happen a lot anymore. Witnesses trying to identify somebody now don't do it with lineups that you see in TV and movies against the wall, 12 people, what have you. But when it did, Jason Hill is an Indigenous man in Hamilton, Ontario. Back in the 1980s, there were a lot of convenience stores being knocked over by somebody. And the general theory is that, in fact, it was Indigenous. The person, so the owners of these stores basically said to the cops, I didn't get a very good look at him, but I'm pretty sure he was Indigenous. So 11 or 10 of them basically made that call. So the police knew Jason Hill. He already had a bit of a record, and that's always a tell, right? Because sometimes the police, go to the lowest hanging fruit because if they think somebody that is already in the system, is already the kind of a person who can commit a crime, and so it tends to be somebody they look at pretty quickly, either to take them out of the frame or put them in the frame. In any event, Jason Hill was put into a lineup, 12 men, 11 of them white, and him, right? And these witnesses knew that the person who knocked over their stores was Indigenous, and he was the only Indigenous person in the lineup. That was in 1985. That went to the Supreme Court of Canada, and the Supreme Court of Canada found that wasn't negligent. The Supreme Court said, and they said, at that particular time, that was accepted practice for the police. And so what happened was he sued the city of Hamilton Wentworth for damages because of the wrongful conviction, and he lost the case because the court said that ID was okay in 1985. Right? Okay, false confessions. False confessions are found in 25% of all wrongful convictions. Right? And this is a kind of a number that surprises people, because when you recant a false confession, nobody's going to listen to you. Nobody's going to believe you, right? No matter what you say, and people who give false confessions tend to recant them pretty quickly, but that makes no difference whatsoever. If a jury hears that somebody confessed, yeah, they may want to take it back later, but they confessed. Why would they possibly confess to the crime if they didn't do it? We don't care if he changed his mind, right? He confessed, right? And that's the way they treat it, right? But police have long known that suspects will admit to crimes they did not commit for several reasons, including mental illness, desire for attention, desire to protect loved ones, but more often than not, they'll do it to get out of an abusive interrogation. And the Supreme Court in King is very easy on the police when it comes to interrogations. It doesn't, they certainly have to give you the right to contact a lawyer, but once you do that, right, and 9 out of 10 times it's going to be duty counsel from a number on the wall, right? Once you do that, there's no right for them to be there when you're being interrogated, right? So they don't get to come down and be part of that system, whereas in the US and the UK, you get to have your brief with you pretty much 100% of the time. So they don't do that. You can ask for your counsel again and again and again and again, and they can ignore that, right? You can tell them that you want, if you're accused, that you want to rely upon your right to silence, and you can repeat that, 20 times. They can ignore that and keep questioning you. So, the Supreme Court in Canada has given the police a lot of leeway to, in their terms, basically fight crime, right? And fighting crime means, get a conviction, any way you need to get it. Extended pretrial detention leads to false confessions. For example, time served, and that's a very, very common phenomenon. Indigenous population overall are at the bottom of almost every index with respect to educational levels, employment opportunities, housing conditions, and per capita income. And these are a self-fulfilling prophecy. Now, if you don't have, if you're a person and you're trying to get bail and you're not employed, you don't have a fixed address, you're not involved in an educational program, you don't have strong links with the community, getting bail is a tough ask. Right? Chances are you're not going to get it, and a lot of Indigenous accused don't have these factors in their favor in order to in fact be granted bail. And it often leads to pleading guilty to end time in jail without regard to being innocent or guilty. Right? You're going to spend so much time in remand custody, as in waiting for your trial, that you're going to get a deal at some point, unless we're talking about murder or what have you, but you're going to get a deal at some point that says, for time served, plead guilty, you're out of here, whether you're innocent or not. And they'll plead every time to get out. Right? Studies of provincial court data reveal that Indigenous accused persons were 1.34 times more likely to be held in pretrial detention, that's 55% versus 41%, of white charged persons. Of adult males between the ages of 18 and 34, Indigenous persons spend approximately 1.5 times longer in pretrial detention. Indigenous charged women aged 18 to 34 were 2.4 times more likely to be held in pretrial detention, 48% compared to 20% of white women charged. More people now spend time in jail waiting for trial than due to sentencing after conviction. I did this chart quite a few years ago, but it still holds true. This is a chart basically with respect to admissions to jails and relates sentence custody to remand custody. So back in 1982, this button right down here deals with basically remand custody, right? The number of remand custody per 100,000 of population. And up at the top was sentence custody. And then you can see over the course of basically 22 years that they're inversed. Sentence custody is here, remand custody is up there, right? And that just compounds the problem, right? You have so many people in remand custody trying to get out that they'll do anything, they'll plead to anything to in fact get out. And that pie chart basically is the same thing. 64% of remand custodial admissions are 64% of all remand admissions are remand, 36% are custody, right? And that's just crazy. Okay, in the United States, under the National Registry of Exonerations, which includes over 3,000 people who have been wrongfully convicted since 1989, 800 of those falsely pled guilty. 800 of the 3,000, right? We have a newly formed Canadian Registry of Wrongful Convictions. Kent Roach, law prof at U of T, put this together. And of the 83 people on his registry, he just started it last year, 15 wrongfully pleaded guilty. Of those 83, 73% of those were false guilty pleas were made by women, Indigenous or racialized persons, or by someone who suffered from a mental disability. And mental disabilities, you probably all know, is a big problem. Okay, jailhouse informants, so another factor. I'm going to give you a quote from a relatively famous, one of the famous public inquiries into Thomas Sophno's wrongful conviction. This is from a judge who, this is from the judge who was the chair of the public inquiry. Jailhouse informants comprise the most deceitful and deceptive group of witnesses known to frequent the courts. The more notorious the case, the greater the number of prospective informants. They rush to testify like vultures to rotting flesh or sharks to blood. They are smooth and convincing liars. And yet everybody knows what jailhouse informants are. They're basically somebody who's in a jail who will testify, almost always lying, that they heard the person that they were put into the jail cell with basically basically admit to the crime, right? These people do this on a very regular basis. There are jailhouse informants, and it's quite clear in the evidence, that do this 7, 8, 9 times. They're given promises when they do it. They're basically, their sentence is going to be shortened, charges are going to be dropped before trial. Some of them are given money, tens of thousands of dollars of money, and this is basically to falsely put somebody in prison, to stay in prison, right, alleging that they made a confession to them that they totally manufactured. And you have people who have done this 6 or 7 times and are known to have done it 6 or 7 times. And in this particular case, not only the police, but the Crown are complicit in this. Okay, ineffective defense counsel. The Aboriginal Justice Inquiry in 1999 in Manitoba found that Indigenous accused spent less time with counsel and relied upon duty counsel more than non-Indigenous accused persons. Indigenous accused are more likely than non-Indigenous accused to appear in court without a lawyer. While 61% of Indigenous accused saw their lawyers 3 or fewer times, 63% of non-Indigenous accused saw their lawyers 4 or more times. 48% of Indigenous accused spent less than an hour in total with their lawyers, compared to 46% of non-Indigenous individuals who saw their lawyers for 3 or more hours before trial. The lack of time spent with a lawyer, this is probably self-evident to everybody in the room, can have a significant consequence upon how well you do at trial. If you don't have access to your lawyer because you're held in remand custody, and you don't see him or her often enough, you don't give them an opportunity to really delve into the case, you don't basically make sure they're properly prepared for your trial, right? You just haven't had that opportunity to do that. The chances of you being convicted are, of course, much higher, right? And that, of course, leads to wrongful convictions. And that's why this is one of the factors leading to systemic causes. Prosecutorial misconduct, that includes, of course, tunnel vision. Tunnel vision doesn't take place solely by police. It includes Crown to some degree. Again, they have to be complicit with jailhouse informants as well, right? This is a case, 1991, in the Supreme Court of Canada called Regina and Stinchcombe, Rex and Stinchcombe now. Basically, it involved a lawyer who was charged with fraud. The police had evidence from his secretary that exonerated him, essentially. It was exculpatory evidence, and they kept that from the defense. Right? Did not tell the defense. It took a long time for Stinchcombe to find, and he was convicted. It took him a long time to find out that evidence was out there, because obviously he couldn't talk to her after being charged, because it's one of those things that happens. The Crown kept that evidence until it was finally exposed. So this case is now constitutionalized, right? It's now part of Section 7 of the Charter. So Crown, has to give you full and complete disclosure when you're charged now as a function of this case. And if you don't, and if it's an egregious non-disclosure, the case is likely to get tossed, right? And that's what that has there. So that case put to rest the long-standing issue of whether the Crown could purposely deny the defense evidence that the Crown found would be harmful to their case. Okay, faulty forensic evidence. So this is the tail end of the actual factors. So this is kind of interesting because people, and this is the CSI effect and what have you, watching a lot of TV and movies, tend to think that forensic evidence is God-given, right? That it just doesn't make mistakes. And that's just not the truth. Having said that, however, DNA evidence is the silver bullet, right? It's very seldom will DNA evidence get something wrong, except if the people who are dealing with it do something wrong, right? So the science is excellent. Sometimes the people working with it aren't so much. So it's got both a great potential to convict guilty and to exonerate the innocent. And again, as I said at the beginning, it was the genesis of the wrongful conviction movement worldwide, right? So courts have now overwhelmingly accepted the utility of DNA evidence in cases where biological material can be found at the scene of the crime. This is incredibly important because only 10 to 15% of all cases have that kind of evidence. Right? It's going to involve virtually close contact. So homicides, sexual assaults to a great degree. Not many other kinds of cases have evidence, DNA evidence that will be of any benefit. The use in hair and fiber comparison evidence, which has been in place for over 50 years, is junk science. Right? It just isn't properly admitted evidence. And it has been around for a long time and has in fact put away hundreds if not thousands of people basically on a science that shouldn't have been accepted into fact in the first place, right? Cases have long been set aside, or have now set aside, that the only evidence was hair and comparison fibers. Guy Pomeran, one of the Royal Commissions, he had actually 3 trials before he was finally exonerated, but at one of the trials there was hair admitted. They found where he was accused of killing his neighbor, an 8-year-old daughter, the little girl. They found her body in the woods, and there was evidence that was put into evidence that there was a hair found at the scene near her body that matched Guy Pomeran's. It turned to be dog hair. but one of his convictions was based upon that. So, okay, so let's talk about the numbers of convictions and wrongful convictions. Okay, good. All right. Okay, so the social scientific evidence of the number of wrongful convictions over the last 20 years has guesstimated them to be between 0.5% to 5% of all convictions. It's a guesstimate, and it's a social science estimate, as in, you know, professors or academics for the most part go out and talk to the police, and talk to judges, and talk to defense counsel, and what have you, to get their feelings about, you know, what are your feelings about this case and that case and how many wrongful convictions you have, because there's no way to tell. Unless we opened every single conviction ever made, right, and looked at it under a microscope, could we basically give an accurate number of how many wrongful convictions are there? We just don't know. But this is what has come to us with the best methods that we have. 0.5% was an estimate given by Marl Zalman. He's on my board, the Wrongful Conviction Law Review, and he's a professor at Wayne State in Detroit. And he came up with 0.5% to 1% of all convictions. More recent, and again from members of my board, as it turns out, came up with about 6%. So anyway, it's anywhere from 0.5 to 5 or 6 convictions. For the purposes of my numbers, basically, I'm going to use 3%. And those are studies that have shown that people are actually factually innocent. So I'm talking about, you know, 0.5 or 1% to 6% of people who, in fact, did not commit the crime. Right? And again, I've averaged it to 3% for the purposes of the numbers today, and that's a pretty fair estimate. Other people have used this number as well. Okay, so from StatsCan, 2021-22 criminal cases, there were 215,113. That's actually low. You know, for the most part, in the last 20 years, it's been around 240,000 convictions. I think last year was actually down about 195 kind of thing. But anyway, 215,000 in this particular year were convictions, or were criminal cases, and of those, 47% of those cases turned into convictions. So 101,000, and of those, 30% of the original number of cases were sentenced into custody. Okay, so those are the numbers we're going to start with. And that's just what that chart says. Number of cases translates down to number of convictions, and then those that are in custody. Okay? So out of the number of persons who are in custody, 33,000, again, we know that 30% of them are Indigenous, so it's a safe bet that just under 10,000 individuals in custody in that year basically were Indigenous. Homicides in the same year, 801 for that year, which equals 0.8% of all convictions and 0.24% of those who are in custody. Okay. Okay, so back to wrongful convictions. So again, if we take the number of convictions of 101,839, multiply that times 3%, you have 3,055 wrongful convictions in that year for data. And that's pretty much, it's usually 2,000 to 3,500 if you take these numbers and play with the percentages and what have you. But you know, 3,000 is a pretty fair number. So that is the number of wrongful convictions each year in Canada based upon social scientific evidence as to the number of wrongful convictions applied to the actual data from StatsCan. All right? And of those in custody, just under 1,000 are in custody, and those who are Indigenous, just under 300. And of those who are wrongful, 24 wrongful homicides in that year. Right? And you'll see how that number actually works out pretty well because it ties in directly with the work of Innocence Canada, and we'll get to that in a second. Right? So Indigenous homicides at 30% equal 8. So there'd be, of the 24 homicides that are wrongful, 8 of those would be Indigenous persons, right? Which is obviously a gross overrepresentation based upon race. Okay. Innocence Canada data, they deal again only with homicides. So they received 34 new cases last year. They currently have 55 active cases and 71 cases on the wait list. And again, those are all dealing with homicides, right? And when we say that the number of wrongful convictions of a homicide was 24, then you're in the same ballpark. So the numbers kind of jive, right? And that gives you an idea of what we're looking at. You know, and this is what they're doing. This is what they've been around for about 25, 30 years. It used to be called AIDWIC, Association in Defense of the Wrongly Convicted. Innocence Canada has been responsible for all the large exonerations. All those public inquiries were almost all as a result of the work of Innocence Canada, right? And James Locke here, their senior counsel for the most part, right? And so, as you can see, we have 3,000 wrongful convictions a year, and this is what we've got over about a 20-year span, okay? And over the last 20 years, Innocence Canada has exonerated 1 Black and 1 Indigenous wrongly convicted person. Tremendously underrepresented when it comes to exonerations. Okay. All right. Now, the potential applicants to the Miscarriage of Justice Review Commission, when it takes place. So, again, the first important fact to note is that applicants to the new commission are not restricted to just homicides. So that's a very enlightened kind of view, which means, again, we're going to have an organization created apart from Innocence Canada to take up these people who don't get on the waiting list if that's where they want to go for homicide. They get on this list to work with this new group or this new organization to take care of those who aren't there strictly for homicides. And that's what that means. Okay, right? So to get an idea on the potential number of applicants upon the creation of a new commission, we should look at other conviction integrity commissions internationally. Right? And I mentioned the countries a little bit earlier. There's not that many when you look at the number of countries there are, but it's important to recognize that there are some and that they're doing very, very good work. So these are the main countries where they have basically miscarriages of justice or wrongful conviction programs and projects in place. The longest standing one and the largest one is in the United Kingdom, actually England and Wales, Criminal Cases Review Commission, right? And Scotland has its own Scottish Criminal Cases Review Commission. Norway has a Norwegian Criminal Cases Review Commission. And New Zealand, which has only been around a couple of years, has its own commission as well. So these are the 4 countries that have these kind of commissions that we are in fact trying to put in place as well, right? And I mentioned earlier, you do have some states, North Carolina, that have conviction integrity units that are part of the state apparatus, right, run by the prosecution service. Okay, so these are the numbers for those commissions. So the UK, this is basically in the last year, they get 1,400 a year applicants. Okay, Scotland gets about 300 applicants a year, Norway 225, and New Zealand 155. And again, it's only been around for a couple of years, right? So let's take that and look how it compares to their population. Okay, so let's get an idea. I mean, how many people does this country have, and how many people within that population are in fact applicants to the Conviction Integrity Commission that's put in place. So in the UK, again, the longest established one, 1,400 cases into a population of just under 60 million people. So 1 application for every 42,656 people. Okay. Scotland, population of just under 5.5 million, 300 cases. So 1 application for every 18,220 people. Norway, same kind of thing, just over 5.5 million, 225 a year. So 1 application for every 24,785 people. And New Zealand, 155 a year, population just over 5 million. So that number, as you see it there, 33,000. Okay. So if you put all those numbers together, so basically out of a total population of 119,299 people, you have 4 applications, which equals 1 application for every 29,825 people, based on those 4 countries put together and divided by their population. All right. So Canada's population, the number as of this year is 39,742,430 people. Right. So if you take that number that we just had here, right, and then you divide it into that number there, right, you will get 1,333 applicants that we can expect in the first year of operation. Okay? And that is pretty much, before I even did all this, that's pretty much what I thought it was going to be, just from my feelings about it, right? And that's a tremendous amount of applications, right? You're going to have a commission that's put into place that will be overwhelmed from day one, right? So it's incredibly important that it's funded properly, and that's a big deal because they have to get the funding in place for a brand new entity. Right? They have to make sure they have the administrative apparatus in place, the commissioners in place. I'm not too sure how many are going to be part-time. Commissioners in place, administrative staff in place. They're going to want to have investigators in, because the commission has the right to do investigations. those kind of staff support people in place, right, they're gonna need a ton of money and resources to basically handle this. And of those applications, basically, the number of Indigenous persons as a ratio of that are 400. So 400, there should be 400 of those 1,300 and change applicants to the new commission that are in fact Indigenous. Right? That's just crunching the numbers on a very relatively simplistic basis. There you go. Yes.
Your statistics on the percentage of Indigenous people in Canada, it was 5.89% in 2015, when the population was around 31 million. The population now is estimated at 42 million.
Okay.
And if you go on the Law Society of Alberta website today, it will tell you that the percentage of Indigenous people is 3% of the population. So this is not a picture of reconciliation. This is a picture of assimilation.
Oh, I agree. If the Alberta government is saying it's 3%, that's incredibly unrealistic.
That's troubling.
Yeah, absolutely, I agree. Right, and that just makes that just extrapolates those numbers into a larger reflection of the percentage of those who are wrongly convicted, those who are Indigenous. It'd be more than 400. It'd be whatever, if you crunch the new numbers, then it'll be whatever it's going to be. It'll certainly be higher than that.
And the Marshall Inquiry, the Manitoba Justice Inquiry, the Royal Commission on Aboriginal People, the Stonechild Inquiry, the Saskatchewan Indian and Justice Review Committee. I mean, even the Berger Inquiry had a big criminal component, as did murdered and missing Indigenous women. And they all suggest that the numbers are much higher than Indigenous people in custody than what you're presenting.
Oh, I agree with you. I mean, all these numbers are generalizations to some degree. Apart from the ones I took from StatsCan, and just as all those reports and commissions you indicated, all 7 of the inquiries that I put up at the beginning of the slides, all of them indicate we need a commission to take care of this issue. And the current system under section 696(1) of the Criminal Code just isn't doing the job. Right? It's just not, and that's why it's so important to get this in place before Mr. Singh or Mr. Shed or Mr. Paulette or whoever is going to end its hope of going forward. So, it's every day we check the news just to see what's happening, see who's making a deal. Any questions?
Any questions?
Sure, yes.
So you mentioned with the old application or the current application process that the onus is put upon the individual to submit the application. It's very onerous. So with this new process, are there additional supports in place to support individuals in going through that application?
Yeah, and there's not, for instance, an arm of the new commission, the administrative arm, that will, it's not like a legal aid system where they'll provide somebody to do that. That's why I'm saying there's going to have to be a new body created to do this. That will in fact do that. It'll do the role of Innocence Canada, but for the vast majority of wrongly convicted people who aren't hitting their wait list or who aren't convicted of homicide. Yeah, so there's a whole. It's a start. Once you get the commission in place, then all of these things are going to have to evolve into place. Yeah. Absolutely.
Any other questions? If not, I'm going to ask you, look on your desk or your table there for the QR code. We are asking people if they would do the evaluations for the sessions. Just important for us at the end of the day for when we do our reporting back on the common person itself. So if you take a few minutes, you want to take a minute. If not, the next session is in, I think it's 15 minutes you'll have between sessions for your next one.
Thank you everybody for coming. I appreciate it.
Thanks, Miles, for your